Hello all. Welcome to Corporate Law Journal channel. In this video, we will be discussing Supreme Court of India judgment under arbitration petition number 13 of 2023, B&T AG versus Ministry of Defence. The topic concerned in this video is that of appointment of arbitrator under section 11 clause 6 of Arbitration and Conciliation Act 1996. We begin with the facts of the case. Ministry of Defence had floated a tender in 2009 for procurement of 1,568 submachine guns. B&T AG, or the petitioner, a company based in Switzerland, was declared as a successful bidder and a contract was executed in 2012. Dispute arose in relation to the alleged wrongful encashment of warranty bond by respondent, worth 201,793 euros. Respondent did this on account of delay in the supply of goods beyond contractual time period and after the scrutiny of the reasons provided by the petitioner. In view of the alleged violation of the contractual terms, in 2016, the ministry directed the bank to encash bank guarantee submitted by the petitioner to recover liquidated damages so imposed on the petitioner. The ministry, via its letter in 2016, informed the petitioner that the instruction for encashment of bank guarantee had been issued after analyzing the petitioner's stand taken in letter dated in 2014. The ministry then deducted amount towards liquidated damages and credited it into the account of the Government of India. The parties were under negotiations till 2019 and could not arrive at a particular settlement. In 2021, petitioner sent a notice to the respondent stating invocation of the arbitration clause mentioned in the contract between petitioner and respondent. In 2023, the petitioner filed a petition under Section 11, Clause 6 of the Arbitration and Conciliation Act 1996, seeking appointment of arbitrator for adjudication of disputes arising out of contract executed with the Ministry of Defence. Limit provisions to this case include Section 11, Clause 6 of Arbitration and Conciliation Act, which mentions that for the appointment of arbitrators, a party may request the Supreme Court or High Court to take necessary measure. Section 43 of the Arbitration Conciliation Act, which mentions that Limitation Act should apply to arbitrators as it applies to the proceedings in court. Article 137 of the Schedule to Limitation Act 1963 mentions the period of limitation in cases covered by Article 137 is 3 years. Under Section 9 of Limitations Act 1963, it is mentioned that where time has begun to run, no subsequent disability or inability to institute a suit or make an application stops it. The Ministry of Defence opposed the petition for being barred by limitation. It was argued that the cause of action to appoint an arbitrator arose in 2016 when the amount was deducted and credited to the government's account. Therefore, the limitation period of 3 years expired way back in 2019. To the contrary, the petitioner argued that since bilateral negotiations continued till 2019, the cause of action was postponed. The bench opined that the Arbitration Act does not prescribe any time period for filing an application under Section 11, Clause 6 for the appointment of arbitrator. Thus, the limitation of 3 years provided under Article 137 of the Limitation Act 1963 would apply to such proceedings. The time limit of 3 years would commence from the period when the right to apply accrues. Mere negotiations will not postpone the cause of action for the purpose of limitation. The bench opined that negotiations and disputes may continue for 10 or 20 years after the cause of action had arisen for appointment of an arbitrator. However, the limitation period of 3 years for filing an application under Section 11, Clause 6 of the Arbitration Act would not be defeated on the ground that the parties were negotiating. While placing reliance on letter in 2016, the bench took the view that disputes between the parties had cropped up in 2014 itself. Hence, the petitioner cannot contend that the limitation period stood extended as it continued to negotiate till 2019. Further, the cause of action arose in 2016 when the ministry deducted amount towards liquidated damages and credited the same into the account of Government of India. This was the end of the matter. To say that even thereafter, the petitioner kept negotiating with the respondent in anticipation of some amicable settlement would not save the period of limitation. The cause of action to appoint an arbitrator would commence from the breaking point at which any reasonable party would abandon efforts for at reviving at a settlement and contemplate referral to the dispute for arbitration. Breaking point should be treated as the date at which the cause of action arose for the purpose of limitation. The bench interpreted cause of action to mean material facts that are necessary to be proved by the plaintiff to succeed in a suit, and it plays a necessary role in computation of limitation period for bringing an action. An important judgment referred to by the Supreme Court include Major retired Inder Singh Rekhi versus Delhi Development Authority, where the court held that existence of dispute is essential for appointment of arbitrator, and a dispute can only arise when a claim is asserted by one party and denied by the other. Cause of action cannot be postponed by repeatedly sending reminders. Under Union of India and another versus LK Ahuja and Company, the court held that whether there is a valid claim in existence and whether the claim is barred by limitation are two separate but important questions. Under Geo Miller and Company Private Limited versus Chairman Rajasthan Vidyut Utpadan Nigam Limited, the court held that what is important for the court is to find the breaking point at which any reasonable party would abandon efforts to arrive at the settlement. In Bharat Sanchar Nigam Limited and another versus Norton Networks India Private Limited, the court held that under Section 11 Clause 6 of Act 1996, covered by residual provision under Article 137 of Limitation Act, the time limit starts from the period when the right to apply accrues. Cause of action means the whole bundle of material facts which is necessary for the plaintiff to prove in order to entitle him to succeed in the suit. The bank guarantee came to be encashed in the year 2016, and the requisite amounts to transfer to the government account that was the end of the matter. This breaking point should be treated as the date at which the cause of action arose for the purpose of limitation. The court held that the case on hand is clearly and undoubtedly one of a hopelessly barred claim, as the petitioner by its conduct slept over its right for more than 5 years. Thank you for watching this video, and don't forget to like, comment your thoughts and subscribe to this channel. Thank you.